Under Penal Code Section 594, California law defines vandalism as damaging, destroying, or defacing another person's property when you do so maliciously. Now, the best way to think of vandalism is as a violence against property. We all know that if you hit someone or you kick someone, if you commit violence against a person, you could be charged with assault or battery, right? Well, if you assault somebody's property, if you smash their windshield, if you paint graffiti on their business, if you cut up their clothes, if you destroy or damage somebody's property maliciously, then that is the crime of vandalism. Now, in order to be considered vandalism, it has to be malicious, which means that it was done willfully, it was done on purpose. If you accidentally damage somebody's property, then you may be liable as a civil matter, that's possible, but you're not liable for the crime of vandalism. It has to be deliberate. Vandalism in California law is a wobbler. That means it can be filed as a felony or a misdemeanor. And the key distinction between the misdemeanor and the felony version is the value of the property damaged. If the value of the property is $400 or less that's damaged, then it can only be filed as a misdemeanor. If the value is more than $400, it could be filed as a felony, and the penalties are much more serious. We had a client who was charged with vandalism. She had recently broken up with her boyfriend, and she was accused of going into his wardrobe and cutting up his suits as a sort of revenge or retaliation against him for the breakup. She denied this, and we believed her. And we interviewed some mutual friends, and we actually found a mutual friend who said that this accuser had told the mutual friend that really he had cut up the clothes and had accused our client just to get even with her, to get revenge against her. And when we brought this witness statement to the prosecutor, they dismissed the charges.